everyone. Today's video is about joint property ownership and I am Advocate Tasmin Singh from NRI Legal Services. Ownership of a property is when an individual owns a property or several individuals own the same property. When several individuals own the same property, it is known as joint property ownership. These several individuals are known as co-owners and they share the property. Hence, it is extremely important for us to know what their legal ownership rights are. Family members like brothers, sisters, parents, spouses can also co-own the same property, or if a non-family member has to co-own a property, it can be a business partner or a friend or anybody that you would like to do business with. In a joint family property, all the family members have a shared interest. A joint family property is co-owned by all the family members who acquired the property together. A joint family consists of siblings, cousins, parents, children. Children, however, have an added right as a legal heir to enjoy the right in the property. They are the legal heirs of their parental property. A legal heir, however, is not a co-owner. The subject of legal heir is covered under the inheritance laws, the personal laws, or the statutory law of the state. Many times parents like to jointly own properties with their children, and that's because it is easier to financially manage these properties with the child's support. It also becomes easier to avail high number of loans on the properties. Let's talk about NRIs. NRIs are known to inherit their properties jointly. They always co-own their properties with other family members. This is why sometimes they are subjected to many disputes with their co-owners or other family members. Now let's talk about joint ownership under the Hindu law. Hindu Succession Act 1956 establishes the Partition form among the members of the Hindu undivided families HUFs. This form allows that an unborn child can be an equal shareholder in the HUF property, which means that after his birth he will be a co-partner, which will be a shareholder in the HUF property. Because the co-partner form cannot work according to the survivorship rights, at the time of death of a co-partner, his share will be devolved upon his legal heirs and not the other co-partners at the time. A co-partner example would be if a couple is expecting a child in 3 months and the father passes away, his unborn child would still have an interest and a right in his father's undivided property. Now let's understand the joint property a little bit. The joint ownership and the co-ownership are basically the same thing. The Hindu law does not provide different types of ownerships, and in a co-partner property, a co-partner acquires an interest in his undivided property of his family by birth. The property rights in India are governed by personal laws and statutory laws. However, there are a certain set of rights that every co-owner has in a property. Those rights are right to use the property, right to possess peaceful possession of the property, right to demand partition of the property, right to restrain other co-owners from alienating your share, right to share the expenses incurred towards maintenance of the property, right to share the charges towards the property, right to sell or mortgage your property, and right to share the benefits that flow out of a property. For example, if your property is rented, then the rent will be shared equally. If you have incurred some compensation due to land acquisition, the profits will be divided equally amongst all the co-owners. The best thing to know about co-owning a property is that you can use the property as the only owner. However, the only limitation is that it should not disrupt the peaceful possession of the other co-owners. The Apex Court has upheld in numerous cases that a joint owner can enjoy the entire property along with other joint owners. which means, for example, if A and B are owners of a property that consists of 4 chairs, it won't mean that they have the right to 2 separate chairs, but that they will be owners of 50% of all the 4 chairs. The Apex Court has also upheld a key point of maintenance of property, which means A and B together will have to share the responsibility of maintaining all the 4 chairs. Now let's talk about partition. Partition is division of shares amongst all the co-owners separately. If a joint family wants to partition the undivided property, then it can be done through mutual consent or amicably, or court can be moved. If the court has to be moved, a plaint will be filed which will be known as a partition lawsuit. Partition may become necessary if the co-owners aren't getting along on key topics like the joint property or the joint businesses. Partition is when all the co-owners separate the shares from each other. However, if only 1 or 2 shares are separated and others remain joint, that means it's just separation of share. NRIs can seek help from property lawyers and property management companies to file a partition suit. Partition can be done through 3 ways: a will, through a family settlement deed or a partition deed, or through the law of inheritance or succession. In India, acts like the Hindu Succession Act 1956, the Transfer of Property Act 1882 and the Partition Act 1893 govern the laws of partition. I hope you found this video informative. In case you have any queries on the topic of joint property ownership, please comment in the comment section below, or you can even write to us on query@nrilegalservices.com. Thank you.